So let's get started. Good afternoon, everyone, and thank you so much for taking time to join us today. My name is Nelson, and on behalf of CryptoBind, I'm thrilled to welcome you all for today's session. The topic for today is new age of data privacy in India. And today we are here to understand how India's DPDP Act is setting the stage for a new era of accountability, trust, and digital responsibility. So before we begin, I just have one question, and I hope you all, take 5 seconds of your time to just answer this question in the chat box. So the question is, if you had to describe your personal data in one word, what would it be? Would it be precious, exposed, or powerful? Feel free to add your comment in the chat box. So I'll just repeat it once again. I'll repeat my question once again. If you had to describe your personal data in one word, what would it be? Precious, exposed, or powerful? Okay, looks like we're getting some answers here. So I see a lot of them have mentioned precious. So I think this perfectly sets the tone, Isha and Deepa. Why data privacy is so personal and so complex, and that is so necessary. So now I am honored to introduce our speakers who will help us decode the new age of privacy in India. So first of all, we have Isha Oswal, the CEO of CryptoBind, and joining Isha is Deepa Ojha, Manager Privacy and Policy at DSCI. So Isha and Deepa, over to you. Thank you.
Yeah. Thank you, Nelson. Thanks for setting it up. We would like to thank Deepa to being here to join us and help us with her experience and knowledge and expertise in the field of privacy compliance and regulations. She's associated with DSCI, and on a request, she actually made herself available for this session
Hi,
where
Isha.
we are going to have, yeah, hi. So we're going to have a lot of insights from Deepa. So when we talk about, yeah, hi Deepa. So
Hi,
when we
Isha.
talk about
Thanks a lot. I
the,
faced some technical glitch.
yeah,
Yeah.
yeah, so we can get started, no problem.
Yeah.
So obviously not delaying for the audience, and we'll just pick up from there where we wanted to also focus on, the global evolution which is happening around data privacy. So there have been a lot of different privacy laws or protection acts which are coming up globally and getting enforced in many areas. And as well as along with that, I'm sure DPDP Act is also coming up. It that also has its own history where it actually started in back in 2017, and then 1819 it was put forward to the Lok Sabha, I mean Parliament, and ultimately now we have it is, I think, almost in the draft stage and it may get closed anytime. But irrespective of that, people are a lot more sensitive and just not dependent on the act, I'm sure. But keeping that in mind, according to you, how have global privacy frameworks like GDPR or CCPA, these have shaped the idea of data as a fundamental right, and how this perception has helped or influenced the India's move towards this act?
Yeah, right, Isha. And thanks everyone for having me here. So at DSCI, we do look into data protection and cybersecurity. And I think even before this DPDPA Act was being envisaged, DSA has come out with the data privacy framework and a data security framework for the general industry as such. So, Isha, yeah, you're right when you said that these global frameworks have helped us shape our Indian data protection law. But I think when we say this data as a fundamental right, I think there's a problem there because we should say data protection as a fundamental right. Data as a fundamental right, I think we'll go to the next side of the story, right? Everyone wants to have. I think with the advent of AI and everything, data as a right has become a different connotation altogether, right? Where industry wants to have as much as data they want to have. But yeah, coming to data protection and privacy, I think principles did existed, right? Like uh, even before data protection was actually thought of, every other constitution in the country, or for that matter, privacy was considered as a part of human dignity and life, right? Article 21 also of the Indian Constitution envisaged that privacy is ingrained within data in the right to life and personal liberty. But I think what the 2017 judgment and the further discussions on DPDPA did was to make it comprehensive and to make it a legit ask for everybody to let me have the control over data protection, right? Now, coming to global frameworks, what I have understood in my past experiences, most of the data protection legislations basically depend on the how the culture and society of that particular jurisdiction is. So if you go to EU, what we see that GDPR is very user centric, wherein they want to have user all the controls over their data through right to erasure, through right to access, right? If I just have to see the rights part of it, they have given, and it's very rigid in some sense, right? How you have to actually have these implementations in place, and then you can go ahead and do your digital businesses. I think US, on the contrary, has taken a market-centric approach, right? Where digital privacy or a data protection is a consumer-centric thing, and market drives the data protection element there. So yes, certainly these experiences of the countries have helped us. China, for that matter, is totally regulated in that sense. China's data protection law. So I think India's data protection law at DSI, where we look at as it's a unique blend of all these three characteristics, right? We have taken something from here, we have taken something from here, and we have given most of the user controls in the form of DPDPA as we see it together. So I think we can't deny that these frameworks have helped data protection law of the India evolve in the present situation as it is. And I think that's maybe the reason what I see is key. It has been, I think, how much? 23 it was enacted, 23, 24, 25. We are still not there. The law is in place, but not enforced. Rules are there, but in a draft stage. So, as an industry, and what experiences we have seen that everybody knows that it is coming. But how to start with the compliance? I think we should start with that compliance metrics as well. Where do I start my implementation from? So, I think global frameworks have their existence, no doubt, but Indians should look at their own diversity, culturality, and then go ahead with the data protection implementation. So, yeah, certainly we cannot negate the influences of these global data protection frameworks for the country like India.
Yeah, great. I think you've covered it quite well and comprehended well. So I'm sure people will now also understand that why is it taking so long is also because it's actually too comprehensive, and as well as it's a lot of complex, as well as it has considered all the global acts and tried to cover maximum out of it. So when we absolutely, I think that is going to make our act very, very strong. But I'm sure there would be some more triggers around the globe, like some incidents or any trends over the last decade, which would have triggered this wave of data protection. And how did this, has created a momentum towards it? Has it contributed towards the formation of DPDP Act, according to you?
Isha, I think when what Nelson started off with, how do we think our data is, right? Precious. So when the society as a whole started understanding that how my data is precious, not only to me, for others as well. AI के आने के बाद all of us can figure it out, right? कि how data is precious. I think the triggers that you are asking for, maybe over the last decade, the various data breaches that we have seen, right? What we see today, in spite of having stronger data protection and cybersecurity measures, we do come across the news items wherein 6.3 billion logo ka data is being leaked, right? We come across like very, I think, known breaches that we can think of as Cambridge Analytica, where we saw for the first time that how my profile on a social media platform can be used as a political instances, right? How it can be used to influence politics of a country, or for that matter, every other single breach that we have heard of. So I think the biggest trigger would be the data related events, personal data breach incidents that has happened in the past. I think over the next past 10 years, if I have to give a timeline, and I think over the past 10 years only, we have seen that how this momentum has gained. We don't have to go, I think, far. The only trigger for Indian DPDP law was nothing but Aadhaar judgment. How our biggest digital identity was being used to link to everything else, and how Aadhaar was construed as breach, like a fundamental threat to privacy. And then Supreme Court has to come down and say, no, right to privacy is your fundamental right, and government has to do something to protect it. And the journey that we have seen from there, that from a very prescriptive law to a very principle-based law, I think the triggers are nothing but to put it in words, two things. One, I think the consciousness among people that yes, my data is precious and I should have control over my data, and this consciousness coming from the data breach incidents. And these two things coming together, nudging government to come out with a data protection law. And the fourth trigger that I can think of, when India became digital, right? I think everyone must be aware that we are celebrating Digital India ka 10 years today. So the digital momentum that we got in the last 10 years, that Jam Trinity came in, we were now having Jandhan accounts, mobile linked to personal information, Aadhaar coming in. So these positive developments, I can't just give the credit to negative instances that we have in the past, but the positive ones as well, right? The digital transformation that has happened, that actually necessitated that you have to have control over data, because data is the essential thing behind everything. So I think these three, four things, positive as well as negative triggers, led to the formation of data protection laws globally. And I think today, if I'm not wrong, the statistics show that more than 190 countries are in some stage of data protection law. Some have already enacted, some are in the draft stage, and some are figuring out, they are incepting it. But yeah, in some form or the other, everybody is now putting attention to data protection law in general.
Great. I think when we talk about a trigger, a lot of people would think about the negative side of it, but absolutely you put it in a very right form, that there are a lot of positive things, or digitization which is happening is another reason for which we need to actually focus on data protection, because there's a lot of data access. So when we, I think one more important point which you just covered some time back is about, every country looking at the Data Protection Act in different way. So with this in mind, how do you feel that this cultural or economic and geopolitical differences, does this impact the way countries look at these acts, like you just mentioned about?
Isha, I think certainly yes. I'll give you a personal example. Do you think in our own homes, like we give value to privacy? कोई किसी के भी रूम में ऐसे ही चला जाता है, right? We do not have a privacy as a culture in the country for that matter. Maybe because of the Indian setup, but compared to the Western jurisdictions where kids have their own room to sleep, I think only after 1 year of an age. But in India, we can start with the very basic things. How do we as a country understand privacy? For every other single instance, even when Aadhaar was not mandatory, identity document, if somebody would ask me, anybody would reproduce what? An Aadhaar card, right? So I think from that sense, privacy as a culture, I think never existed in our country, right from our families kind of a setup. I would really appreciate if you have some any other arguments to this. But compared to the Western countries, I think we are not in that sense. So we follow the principle of Vasudhaiv Kutumbakam, and that's I see totally translating into our digital transformation and digitization journey as well. At that time when Jam Trinity was coming into picture, I don't see that we have taken specific consent. We just wanted financial inclusion, and maybe then we started opening bank accounts through mobile vans, right? So in that sense, and that's how now we see that banks are facing challenges how to go about retrospective consent requirement in the law. So I think it does certainly have certain kind of effect. China as a country which has a very regulated kind of a sector, they would have thought of it more precisely than us. So I think cultural differences, geopoliticals do certainly have a role to play. And another, I think, evident example of this, which I can see, is the way our digital DPDP itself has seen various kind of journeys, right? So if you remember, at DSCI, we know because we were the part of the committee that drafted the actual law, Shri Krishna committee, and wherein we gave a dissent opinion. So our former CEO was part of that committee. She said that how restricted data transfers would have a problem in a country like India, where innovation is also something which is warranted. So we see a very prescriptive version coming in, industry having challenges to comply with a prescriptive law like GDPR. But then we had a different version which had non-personal data elements also into picture. Then we had a different other version with some 89 amendments suggested by the Joint Parliamentary Committee and whatnot. And then what we see at the end of everything in November 22 was a very crisp principle-based version of the law, wherein we talked about certain privacy principles embedded in the letters of the law, but not in that stricter sense which we see in GDPR or a CCPA. But we did have uh, we have something, and I think that's the beauty of Indian DPDPA, that it is now able to cater to most of the stratas of the society, the elitist one who value their privacy like anything, And the unawares one, जहाँ पे literacy ही नहीं है, they are also now given that transparency and accessibility ki notice you have to give them in 22 languages, right? I think the only intent is to cater to that privacy unaware community ki जिनको पता ही नहीं कि what is the value of their data, right? So I think in that sense, it is certainly culture, society, and geopolitics have certainly a role to play. So to cut the answer short, that's the answer that I would like to give you.
Absolutely bang on. You've just covered a lot of nitty-gritties. So I think I'm seeing some questions coming in, but I think we can continue and maybe you would like to take the questions in between or end of the session.
I'm
How
good
shall we?
anyways, Isha, so you can let me know which question would you like me to
I think,
address.
sure. I think we have someone
I think
asking.
it's better that we take it towards then because by then we will cover, I think, most of the aspects of the law as well, and mostly these
Yes.
concerns might be answered. Yeah.
Yeah,
Isha, like,
absolutely.
feel free to put in your thoughts if you feel that there's something different. But yeah, I think that's the intent. Like, I think it's been 3 to 4 years I've been working into this space and specifically working on data protection law and having to hear so many industry viewpoints. So these are like insights that I can share with everyone in the room here.
No, no, I think absolutely it's coming a lot more than we just know what's happening in the background, what's been considered, how much of, study has gone behind this.
Yeah, I'm
So I
telling
think
you,
it's the
like
other
from a
side which
regulator, yeah,
audience
from a
also comes
regulator
to.
also, no, it's a behemoth task to coincide everybody's interest and come out with something which is actually liked by everyone because we don't know the pain they are actually having when they have to draft something for a country like India, जहाँ पे diversity is at every different, like I think every 2 kilometers there is some diverse situation and
Yes,
diverse requirement,
absolutely.
yeah.
And as you said, obviously the culture as a culture, we never have imbibed privacy as a culture. So definitely the best part is there's a lot of awareness now. People understand what data means to them or how important it is. Even those answers has given us a clarity that it is precious and people know about it. That yes, data means a lot to me. So I think this act is also been appreciated. And another thing, I think a lot of people have come forward, given a lot of inputs. So I've seen myself a lot of, back and forth happening. Plus, I myself have contributed in couple of drafts which were circulated through IMEI, DSCI. DSCI had also done a reading of act in every city. I know. So I think
Yeah.
we've given a lot of inputs there as well. So it is becoming a very comprehensive act. So while we talk about this act, definitely, I mean, it's just coming to specifically DPDP Act when we talked on a global context, but talking about DPDP in terms of its provision, scope, or intent of the act, how does this act, talk about rights of individual under DPDP, and how do we compare these with global acts?
Um, So, Isha, like just to start with, I think, as I said earlier, our law is a blend of both GDPR and CCPA, and that's clear from the objective part of that, where it says an act to protect the right of individuals' data protection, and also businesses needs to process personal data for business purpose. So, I think both of these are coming together there. And when coming specifically to rights of data principles in that, I think. I see every other right that is available in all the global jurisdictions. So if we build out certain principles, right, like what are the basic data subjects rights principles? So right to access and erasure is of course there in our jurisdiction. Right to update and correction. Right to deletion is there. One thing unique that is to India is obviously right to nominate, which is not there in any other global jurisdiction except for Philippines, I think, where they talk about some posthumous right, but not in the sense that we have right to nominate in the country. And lastly, right of grievance redressal. Again, I think getting insights from CCPA as a consumer law. If something is done to my data, I have a grievance redressal. I think these are there obviously in some form or manner. And when I think of or try to map it with the principles that I see, data protection principles, data minimization is there that you have to collect only what is required from my end, right? Uh, Authenticity, accuracy, minimization and purpose limitation is of course there, right? And right to withdraw consent in that simple manner in which I give it. I think transparency and accountability is being enshrined there. I think only difference that I can think of from my experience is right to data portability as such, which is spoken about in GDPR, is not there in our laws. Or for that matter, right to specifically opt out, which is there in CCPA, is not there in that form. But obviously, when I talk about right to withdraw consent, and when I read it with right, that specific purpose limitation. I think that is also read between the lines. So that's all. I think in essence, all the data protection laws are giving these five, six minimum rights to a data principle. And when I join all this with the consent and notice requirement, I think the picture becomes more clear that you have to tell me these rights. When what rights
Yes.
I have with you, you only have to tell me. You only have to tell me how I have to go to data protection board. So I think in that sense, very basic controls have been given to data principles in the Indian DPDP as well.
Yeah, right. So as you rightly said, I think Act has consolidated all the rights, whereas maybe if you want to talk a little more about the unique thing which DPDP Act has about right to nominate. So I think that's something which is a little more than probably some other acts has to offer. So
Right.
anything you want to add on that?
See, like we were hoping that the rules, the draft rules will clarify more on this. Ki, what do we mean by right to nominate? Who I can nominate? How long he will exercise my nomination right? So these things are not yet clear as in clear form. But what I understand generally, it's all about my digital existence, right? Like if
True.
I happen to die, but my legacy is still there. Today I recording this webinar with you guys will stay forever, even if I die or even if I get mentally incapacitated. So in that sense, somebody who I can represent or nominate, ki, please look after that this video is not altered or modified and it remains as it is. I think that's a very beautiful thing that the law has tried to do. You exercise my digital existence because my and I think, Isha, it's very rightful also because mostly things are turning digital these days. And with the AI advent and the negative aspects of AI, how deepfakes are churning, how my audio video can be used to do certain a whole lot of things, I think this does make sense. How long, how we can exercise those rights, I think some clarity would be really appreciated there. Ki how, so that companies are also prepared, right? Ki if Deepa is
Right.
nominating Isha to exercise rights on her behalf, how long Isha will exercise her rights? What will be her specific responsibilities? So I think these clarities would be much appreciated, but let's see how we can go about it. But I think the intent behind this provision is really noble that my existence, even after I go, should remain as it is. Yeah.
Yeah, yeah, right. So I think Deepa, while drafting this, it's been thought way ahead of what's coming. So definitely that's been considered while drafting this act. So while we talk about, when we talk about personal data or it's about individual rights, but it's also about data fiduciaries, data processors. So there are a lot of such terminologies used in the act.
Yeah.
But to be precise, if you have to talk something around obligations of these data fiduciaries and processors, what could be that under this act?
I think Isha, you know what, as a layman, understanding of even a basic data protection law would help the audience out here. So if I have to speak about data, DPDPA specifically, I think Section 8, yeah, if I'm not wrong, Section 8 of the Act talks about specific obligations of the data fiduciary and then rules clarifies on some data fiduciaries. When we have suggested this, what does it mean by? But two caveat that I would like to give here to the audience. Number one, as against every other data protection law, which have talked about the responsibility of joint data controllers or data processors in EU GDPR context, our law has specifically said that if you are a data fiduciary, and who is a data fiduciary? If you are determining the means and purpose of data collection. So the basic test that you have to see is, am I collecting the data and am I processing the data for my business purposes? If yes, I am the data process fiduciary, and then I have to take care of all the obligations set out in Section 8 and then Section 9 if I am a significant data fiduciary. So I think the only two connotations to data fiduciary in our country is data fiduciaries and significant data fiduciary. Who is going to be a significant data fiduciary is still a question, but if you should assume that if you are processing vast amount of data, volume of data, you are a significant data fiduciary. So I think in that context, the first test that you have to undertake is, am I a data fiduciary? If yes, all the obligation lies on you. Please don't be like very casual that data processors will have data responsibility because Section 8 subclause 1 specifically says, irrespective of any contract to the contrary, data fiduciary is responsible for the compliance of the act. So that thing I have to be like has to be made very clear. And then it comes to the second thing. Ki, if you are starting off with your compliance journey, the first thing I think I advise everyone to do, please go back and review your contracts. Even if your data processor does something wrong, it's going to come heavily on you. data processors have no responsibility. So in that sense, एक तो ये clarity होनी ही चाहिए. And then second, obligations part पे if you have to talk about, again, having those data protection principles rightfully in place, right? No matter what the law is, if you are complying with the principles that data minimization, collect only what is necessary, purpose limitation, maintain accuracy of the data. So you have to have these metrics in place. So if I have to specifically talk about these responsibility, the number one is obviously comply with the provisions of the act. Number two, obviously have reasonable security safeguards for whatever data you collect or you have in possession. Number four, process only collect data only that is necessary. Implement privacy enhancing measures could be one. If you are collecting children's data, comply with the requirement that is set forth in the law. And yes, have enter into data processing agreements only under a valid contract. So these are some obligations that are set forth in Section 8, and rules clarifies it. Okay, what do they mean by reasonable security measures? They mean that you have to have data security measures like encryption, obfuscation, data masking. You have to maintain logs of data forensics, right? For if something happens. If there's a data breach, you have to report the data breach to the affected data principals and also to the data protection board. And then rules clarifies how much hour time you have, 72 hours, right? But like these are some obligations that are there in the law, and then we all know that with all these obligations you have an attached penalties. If you fail to do this, what's the repercussion? And I think that's something which industry is freaking out, but I still believe our Indian law is better because we don't have a regressive provisions like 4% of your global turnover. We have that maximum capping, and then we talk about कि वो भी हम तब लगाएंगे when we assess these factors कि what were the reasonable security measures you had in place. What did you do to redress the grievances of a data principal? What did you do to ensure that this nothing happens in future? Then when I read this with the voluntary undertaking provision, what I read, Isha, for sure is our Indian law talks about a proactive compliance. What government wants that please go ahead and do your implementation. And we are not sitting here to levy a penalty on you, but to let you know that you have to take care of the data that you have with the country. So I think obligations ke saath, and the duties part, obviously we can't forget, right? Ki if a data principal have a duty to maintain accuracy and consistency of data, a data principal is also asked to give or furnish authentic information, and then associated penalty with it. So I think in that sense, I see that DPDP is a really beautiful law which says ki there has to be balancing interest. But yeah, with this, I don't know, it's my personal opinion. Only challenge that I see, Isha, is that we don't have a right to sue personally, right? If my data is breached, I should have the right to get compensation or whatever to make it good, right? But what I see, these penalties, even if they are levied, they are not coming to me directly as a data principal. So I'm not getting any good. So I don't know what is the benefit that I go and report that incident to you, right? So who is actually benefiting from all this arrangement is something I think is still challenging, but we'll see that how this can be figured out. But personally, I feel this is an issue. Ki I should be benefited or I should get the redressal actually when my data is being breached, right? Only notification of a data breach might not help me as an individual or a data principal. There should be some extra element there.
Okay, I think that's the new or interesting element. But since you've covered it quite well, because the moment we talked about obligations and we talked about responsibilities, the next thing pop up in my mind is about penalties, which you already talked about, right? When there are obligations, obviously there are certain penalties which have been defined by Act. But somewhere I think these penalties will at least try to ensure me as an individual when I say, as you said, what are the benefits or how do I get compensated for it? But I think one important thing is if it doesn't happen, I think I'm happy with it. So if there is a
Right.
penalty and if organizations are conscious enough to implement right measures, apply those, solutions, then definitely I think I'm happy about it that at least the data is been protected, it's been taken care. So
Yeah,
when
I totally agree.
yeah, so even if that happens, I think that helps me as an individual and it serves my purpose. So when we talk about now, this protection, definitely it's something about being ready, industry being ready for this act or implementing measures. So we talk about the impact and the readiness of this. While doing so, I think it's important to understand the implications that businesses would have and how they can prepare themselves for compliances. So what do you think about it?
Um, Isha, I think it's already been 23. Everybody know that this is coming, right? So I think when you have to start off with your compliance journey, right? I think the first step is obviously to understand what is the intent of the law, where I am falling short of. So I think the very first thing that I'll do, I'll start off from the very first thing, okay? Uh, so as an organization right now, what practices we have? We have a privacy policy. We collect data for certain things. We process it and we do our businesses as it is. But I think the first very section, right? Consent and notice requirement at all. Where do I stand? The first step that every organization should carry. Am I a data fiduciary? If I am a data fiduciary, for what businesses, what functions? That's the second question. If I have segregated, so I think अगर मैं हिंदी में बोलूँ तो only one thing is required, introspection. कि from a DPDPA lens, where
Hmm.
do I fit into the first category? If I am a data fiduciary, chalo, I have determined that I am a data fiduciary. The second step that I have to do, what are my data touch points? Where do I collect data from? The second element would be this. Once I have done this data discovery part, am I collecting it under valid purpose? If yes, am I giving them notice? If yes, how long is my notice? You have to like have these questions asked within an organization, and maybe a DPO or the person who is responsible for data protection activities would be responsible for that. Then comes to the notice and consent part. If I am doing this, how should I be giving consent going forward? And this is the data I'm sitting right now. So again, law has given us some laxity when it says ki for the data that you are already processing, you have to give a retrospective notice. That's fine. There's no timeline defined, but organizations have to take cognizance of this fact. Still, they are sitting on tons of data. So if breach happens, you have to go back and tell all the affected data principals. So I think one exercise should be this: ki this data which I am having right now, do I actually require it? If no, I think they should go ahead and delete it, because data is nothing but a time bomb you're sitting at the moment right now. Because if there's something happening there bad with that,
Yeah.
penalties are huge, compliance obligations are huge. No one else can deny, because going back and telling each and every data principle is a huge task. Then comes the gap fit assessment, maybe. Where am I falling short of? Maybe work in teams and try and think whether rule ka six element, reasonable security measures are in place. What protocols do I have? What privacy enhancing? You know what, Isha, going forward, I think the only solution I think is to have maximum use of privacy by design and security by default approach. And for this, I think there are numerous solutions available in the market which will help you do this, right? Be it consent or drafting public privacy notices, or to have encryption solutions inbuilt at your every data touch point, data purging solutions for that matter. So I think industry should look out for all these solutions available in market. कि data leak prevention के लिए which are the solutions that I can employ? कि prevention is better than cure wala approach is, I think, is the best approach.
Yeah.
Once you have to start off with the enforcement strategy at least. And I think organization like yours with some available technologies might certainly help industry out there. So it would be really like helpful or useful if or you go out there and tell people that these are the solutions we have to help you do encryption, to help you do anonymization. So I think technology and law has to meet together in order to start off with the enforcement of the DPDP and all the regulated regulations for that matter. I don't think privacy as a law can be seen in itself, because the privacy is a subset of security, right? Data protection is a subset of whole larger gambit of cyber security. So I think it has to be a harmonized or comprehensive approach to look at these kind of regulations.
Um, yeah, I think what you're saying is right, because what we're talking about, it's actually the amount of impact it actually has on an organization when you talk about data. And if it's not protected, definitely it's going to cost huge, or it's going to cost bomb. And as well as there's a trust, which is a very big factor, which
Right.
organizations also have to manage. And when you talk about technology, I think you're right. It's no more now, legal is separate, or IT or a technology stands separate. This act has made a revolutionary shift where we'll find a lot of law practitioners, lot of technology practitioners, or privacy people, or we call it as, or whether it's DPO, which has been mentioned in the act. So it's like a culture where everybody has to work in harmony, whether it's nothing that only CISO, only DPO or
Yeah.
CTO or a lawyer. is responsible for this, but it's more to do, hand in hand engagement where these things are required. One is from a compliance point of view, your checklist in terms of whether you are meeting compliance, your solution, I mean, your infrastructure is compliance ready. And third is deployment of various technologies, which you mentioned, definitely encryption, tokenization, and many more. So if we, when we talk about the compliances, regulations, I think we've talked a lot about what the law says, how we want to go about the law, what kind of a readiness we should have. But anything you want to add on in terms of technology, which you mentioned in terms of encryption or tokenization, what kind of role these technologies play in DPDP compliance? Maybe a little more deeper in case you want to add on.
Um, See, like I'm a lawyer by training, JISA, so I may not have the nitty-gritties of technologies as but I know that so in the past we have worked on a few privacy enhancing technologies that if I have to ensure my DPDPA compliance or for that matter general data protection readiness, these are the technology solutions that I can have. So one thing that you have to for certainly look out, and if you look at the language of the law itself, Section 8, it says data fiduciaries should have reasonable security measures and implement appropriate technical measures to ensure compliance with the Act. So when they talk about the second part, implement technical measures, it simply
Right.
means that you have to have privacy enhancing technologies in place. So some technologies I know, encryption is obviously that you can't see what is there. And I think every data protection law, I think somewhere the basis is encryption. Data anonymization could be other technology where you can I think take away the PII elements from the data and you make it a non-personal one and then maybe use it for your own business requirements. Third is tokenization, which will help you keep better logging of the data, right? Create tokens instead of
The actual
data
data.
itself. Yeah,
Yeah.
the fourth, another could be again data transfer when you are while you're doing data transfers or you're using cloud solutions, maybe get the best of the security solutions offered by these cloud entities because they know how to have that key arrangement and ensure that you are only the controller of that data. The fifth element now comes to the your review of the third party contracts, right? You are having all these solutions in your organization, in your data processing, well and good. But I think you have to have take measures to let your data processors also do that. And while you are doing that, you also have to maintain that thing that you are not compelling or you're not killing businesses of the smaller entities who do not have these kind of solutions available. So maybe again that thing that you were saying now, Isha, ki all of us in the ecosystem should have to work hand in hand, right? Ki
Right.
requirement of one should not be an obligation for others or a business killer for others. So they have to tell the technology, share the technology, make available, like disseminate what you have, right? Through these kind of webinars, through these kind of technical webinars. Ki, see, this is what we can offer you, right? So I think everybody has to talk to each other. And then comes the very crucial element, Isha. Like in an organization, I think a person sitting at the reception desk is the person first data touch point, right? Who collects information of every visitor coming into my organization. He or she may not be at a CXO level who is defining strategies for the organization, but she or he needs to be aware कि data
Right.
protection में उनको करना क्या है. So I think the very first thing I will say, or the very prioritized thing should be to give this training to my fellow employees, to my fellow organization people who may not be that critical from the management point of view, but from the data collection point of view, because it can happen from anywhere, right? So I think that strategy has to be built wherein everybody is included. Strategies are defined in the boardrooms, but implementation is happening from the very first desk of
Yeah,
the office. Yeah,
absolutely.
so I
From the
think these are
first
four,
data
five
touch point.
technology, legal, and regulatory solutions that I will say would help.
Okay, great. I think what you've said is right, that it starts from awareness, which is very, very critical. Second is just to add on, since obviously it cannot stop me when we talk about technology because that's what we do day in, day out.
Yeah,
So that's what I would say, what we work on is privacy enhancing technologies is one of the thing which we work on when you talk about encryption, tokenization, or just one point which you made about cloud. Obviously, a lot of organization or small organizations make use of cloud just to have ensure their data is safe or protected. But obviously, there is something to add on which is called key management solution. So when
right.
you have to have control, as you mentioned, control of your own key, it requires the KMS solution for to ensure that they have the control of the key. because cloud may protect your data and keep the key with them. So that is one thing which is needed. And anonymization, pseudo anonymization, and data masking. So, yeah, absolutely. I think you rightly mentioned there are these technologies which are available, which helps a lot in data protection. And as you mentioned, I think we'll make a note of it that we will come up with some more technical sessions or technical webinars which will talk more about the privacy enhancing technologies, which will give more inputs on how each technology works so people can figure out what they want to use, how they want to
Right.
use, what is more suitable to them. And audience will be able to choose something right for their organization based on the size, volume, usage of the data. They can choose what is right for them.
Yeah,
Absolutely.
I think that's the best. I think this is the opportune time to do this because everybody, I believe, would be now starting off with their implementation journey. And then they have to do it from the beginning or from scratch. I think they will have their solutions inbound with their processes right from the very beginning. कि बाद में
Yes.
लगाने से अच्छा है कि we'll fit it into right now so that security, privacy by design
Excellent.
and security by design is ensured from the very first step.
True, true, absolutely. So I think there's so much to talk about, but I
Yeah,
think if we continue, it will take quite long.
forever, I think. Yeah.
Yes, absolutely, because our act is also that vast. But I'm sure we'll keep having these sessions. We'll also have some of more in case we come up with some request on around the compliance and governance and all. We'll again definitely get in touch with you. Meanwhile, I
Sure.
think what we can do is we can also just, I think there are one or two questions in case you want to pick up. So maybe if you have something to add on, you can add on to that.
Mm.
One is how we sure it won't become another unused law that government only enforces harshly when it wants to, and how will government know if company is not following the data protection law?
I think we can take a question. So in the data protection law, they have set up an enforcement authority called the Data Protection Board, right?
Yeah,
And Data Protection Board, unlike again one point of differentiation from other global jurisdictions, is it's a quasi-judicial body. It doesn't come up with the frameworks or guidances. While it might do it through other forms, central government has all the powers, and what we see through this BRD mechanism, right? Ki how a business requirement development for a consent management should look like. MeitY will still have these practices, but the question that is asked that how will government know? Of course, you will only tell them. How? Through audits, right? So there's a requirement that if you happen to be a significant data fiduciary, and who is a significant data fiduciary, we don't know yet, but we know for sure the banking institutions, the hospital healthcare institutions, given the vast amount of data and the sensitivity of data that they possess, they are going to be a significant data fiduciary. And you know what, personally, whenever I have to tell Isha that how to start off with my compliance, I always say, presume you are a significant data fiduciary and do your compliance, start off your compliance journey because
yeah,
it's better to do it for the
maximum.
maximum right.
Right.
So in that case, you have to have a yearly audit, DPI, data protection impact
Yeah,
assessment, and the rules clarify. Okay, whenever you are starting off new technology, or in a year, you have to do it once, right? Submit the report of the significant findings to the data protection board. So it is through this regulatory compliance requirement you would be telling data protection board that something like this has happened. The second
absolutely.
channel, I think, is the data breach reporting, right? If something has happened, you have to report to the significant, you have to report to the data principal, and you have to tell the data protection board. And obviously, data protection breach is a subset of cybersecurity breach. So you will go and report to certain. You will go and report if you are a fintech entity, you will go and report to SEBI. If you are a banking entity, you will go and report to RBI. So I think you will yourself tell that this thing has happened, and maybe, and then obviously the third route is cases, right, which is filed through data principals themselves when they do not get the grievance redressal from your end, and or data protection board may uh, come to you and ask for a certain solution. So I think these are three, four ways where government will come to know for sure that something like this has happened in your organization.
Absolutely. I think DPI has been already built-in mechanism, which is
Right.
going to happen on a regular intervals. And it's very
And it's a
clearly
best
defined
practice
when to
to do
do it.
also, right? Like it's
Yeah,
always a best practice.
absolutely. I think there's one more. Can you educate us about status of data portability
Okay.
and rights in India?
Isha, like to be honest, data protection law does not give this right to data portability in the country. But if I have to build in some other context, right? If you are aware that this draft digital competition law bill came into picture, right? Last year somewhere, draft digital competition bill was under consultation, and there was a provision of data portability provisions. Key companies or the big techs, significant systematically important digital intermediaries. There was a term which said that if you are a SDMI, you have to have a data portability mechanism in such format and manner that can be used by everyone. And I think from a data protection law perspective, one thing that we have to very be clear in our mind is data protection law is a very individual centric law, right?
Yeah.
So if I am having my data in one organization and I want to take it to other organization, it certainly gives me some ease, right? But to implement it from an organization perspective, imagine the pain that a company would have to take to have a standardized format to take data from one company to another, and that too for one person. We are facing challenges with the right to withdraw consent only, right? How to have structural and architectural changes in our data processing system so that we can enable this. I can take your data and process it for giving you services, but not to send you marketing emails. That is in itself a challenge. Imagine a situation where data portability is a part of data protection rights, and every one individual coming to you and asking, hey, port my data from Max Hospital to Fortis Hospital. Imagine the problem that you might face. So I think there are other laws I'm envisaging that will certainly have the rights, this data portability rights in place. But I believe that the government would have looked at from a more commercial perspective than an industry, than a data protection law individualistic perspective. So for sure, I think this will be there in some form or other, but not obviously in the data protection law.
No, absolutely. I think because this we are talking about data portability, but if we even stick to data within the organization, as you said, it's still a challenge where we have to figure out when there is a data, if there is a consent deletion request or something, how do we
Right.
centralize it? So definitely at GISA, we are working on, certain solution which which can help industry to centralize the entire sensitive information or the data and build a world around it, and where these all the processes can be made simple. But that's something which we are working on under CryptoBind.
Mm.
To stick to this, yes, then data portability is a little vast or a complex thing for now,
Right.
as you rightly said. Okay, I think if you have
There's
a
a
guess.
question that
Yes.
this is a question that all of us are deciphering that by
Yes.
when we should have the rules. But I
Yeah.
think, Isha, what I anticipate honestly is that I don't see that lots of things are going to change in the rules itself, because
Yeah.
it is, I find it to be an extension of what is stated in the law. So I think we should take it as a baseline and should start off with our implementation, irrespective of waiting for the rules, because I think unnecessarily we'll be delaying our internal processes of DPR and data protection law implementation. And you know what? The second experience that I have it, mostly organizations are doing some parts of it in some form or manner. It's just that the need is to sit down and organize and structure it better from the sense of DPDP implementation. And two, three things, or I think the major hit is obviously consent and notice requirements. Because compared to the organizations who are GDPR compliant or a CCPA compliant organization, they are also processing data on the basis of legitimate contracts or legal contracts, which is not a ground in Indian law, of course. So I think structural changes, organizational change, structural and architectural changes, better word would be architectural changes, and maybe restructuring of all your processes for DPDP would help. In spite of waiting for the rules, we should start off with this implementation journey.
Absolutely, because I think we are seeing this is happening in a lot of organizations, especially with banking also or insurance, which could be significant data fiduciaries, right? These
Yeah,
SDFs, they have started implementing it because irrespective of the act, there are organizations like RBI who've been, very sensitive about it since ages, and we had one project which we had done with banking industry, obviously, where this sensitive data protection is already in place, and
right,
still today, there are a lot of organizations which are actually going ahead and doing it, irrespective of when the law is going to come, whether it will be enforced, when it will be enforced. Irrespective of that, the fact is that sensitive data is crucial. It is important, and
right,
people are sensitive about their data irrespective of the act. So, act is going to be a guiding factor or a guiding force where it will make sure that when enforced, people are more compliant, they're more strategic, more systematic, process oriented, and maybe more as you said, architectural driven. So those things will come in place. But when it comes to basic sense of protecting data is definitely there, which needs to be done.
Yeah.
So
I
I'm
think,
sure. Yeah,
Isha, we have to take this law very positively in the sense that what is to be done has been told by the act. You are required to do this. I think
yeah.
mostly how part is left to you. You figure out how do you do this what,
So what you're
right? So I
supposed to
think,
achieve has been very clearly given to you. It's very
yeah,
well defined, and there's a flexibility also given. How do you do it? But you
yeah,
just have to make sure you do it in a right way. That's more
right.
important.
Yeah, so I
Yeah,
think one should be quite happy and relaxed about it. I have been given choices that how do I want to do it.
yeah, right. So, so I think I'm sure. I hope we were able to give quite a lot to audience. We were able to help them out with navigating through the law, where it started, how it came in, and what is
Yeah,
expected out of it. So definitely it should help. I think we have something here. Is you have tokenization data, then do call it
okay.
PII or not? Do we call it PII or not? So tokenized data means it's the other way around, right? It's actually what we talk about is PII data is personally, identifiable information. So the PII data is something which is very well defined, which is clearly defined, and we call that data as PII data. And we have to use various technological solutions like tokenization is one of them, which we can use to protect or tokenize the data which is available, which is like PII or other sensitive data, which is defined as Deepa rightly mentioned, right? What is the sensitivity of that data? You have to identify, and that data needs to be either tokenized, encrypted, or masking, whatever is the right solutioning needs to be applied as per your organization need. So I think we were able to, overall help the audience, and I'm sure we should be able to give them more with upcoming sessions. So
Right,
thank
Isha.
you so much, Deepa, for being there and helping us out. Thanks everyone for joining us for today's session. Your presence and engagement is showing us that how everybody is taking data protection or privacy seriously, and
Right.
it's good to see people wanting to know more about it. So obviously, even at CryptoBind, we are focused on data protection, just not as a mandate, but more as a mission where we are able to contribute towards the awareness as well as help organization achieve this compliances and actual data protection through the solutioning. Okay. Thank you, Deepa.
Okay, thanks everyone. Thanks,
Thanks a
Isha, for
lot.
having me here.
Yeah. Stay safe, stay secure. Bye.
Okay, bye.
Thank you, everyone.